Hi, everybody. It's Chad and Davi back with the BaseFirma Brazil Transfer Pricing Podcast, covering everything you need to know about the alignment between Brazilian and OECD transfer pricing standards. We've been out the last couple of weeks in the market, in Brazil on road shows, talking to industry and resident experts in transfer pricing across Brazil. We've been soliciting some great feedback. We're super excited to bring you today's episode covering intangible transactions under the new Brazilian transfer pricing rules. So let's move on to our topic for today. It's one of my favorites personally, and a relatively new one for Brazil for reasons that we'll get into. So Davi, let's start off at the basics of intangible transactions, as has historically been the case for Brazilian transfer pricing. Really not a concept, right? We've got these, kind of four pillars of transactional types under OECD and US standards of tangible services, intangible financial transactions, right? Noticeably missing in historical Brazilian legislation has been any real coherent policy by the Brazilian tax authorities around the pricing of intangible transactions. It's always been kind of conflated with the idea of service provisions. So can you give us a little bit of a historical background as to why that was the case and why Brazil never really saw fit to introduce intangible regulations in their transfer pricing legislation?
Yeah, I love backgrounds in Brazil. And as you are a specialist in intangible transactions and transfer price, I'm not, because we have never analyzed intangible transactions based on the current and the old Brazilian transfer pricing rules, let's say like that. Our rule was established back in 96 and makes some reference about the intangibles, but just to make sure that the transfer pricing rules are not applicable to that. As you mentioned, in the US, you have these four pillars for transfer pricing, and in Brazil, we only had three. That was the import and export of tangible transactions, of tangible products, services, and financial transactions with related parties. That was basically loans and the interest that would raise from those transactions. The intangibles was not even accessed by the old rules. The rules that regulates intangibles in Brazil is back from 64. And it is a law that it was really different from other countries as well. It has this restricted limit of deductibility in Brazil of how much the companies could pay for those intangibles that be charged to the Brazilian entities, the Brazilian multinationals. And there is a specific regulation to that. And an institute that defines, that is regulated by the Ministry of Economics in Brazil, that defines which are the limits for those in royalty payments. And that was something that always create a huge problem for the multinationals in Brazil. And most of them didn't even charge because the limits are so tight. So the limit in Brazil is from 0 to 5%, actually. And this limitation depends on which are the royalties, which type of royalties are you dealing with. If it is a trademark, if it is only technical knowledge that you apply on your production, if it is something that will create more facilities as you can sell the products like the marketing or any other functions that would create opportunities for improving the market in Brazil. All of those transactions should be analyzed. And for products itself, there is the INPI, there is this regulatory agency in Brazil that defines the margin for each line of product. And depending on the application, you will receive this percentage that you can apply on those transactions based on your revenue from the sales of this product. That limits a lot because it's a black box. You don't know which are the percentages that will come up from this analysis of the NPI, and this analysis takes a long time. 5 years, 6 years, and the companies doesn't even have the registry of the product to have the final definition of what are the limits to make those payments in Brazil. So that was the main point that Brazil needed to address based on the new rule, that is the royalties. Now it is incorporated. So it was treated apart from transfer pricing. So in my 19 years experience in Brazil working with transfer pricing, I have never dealt with the intangible transactions in the transfer pricing rules. So that was something completely new for the Brazilian taxpayers now.
Interesting. And Davi, I think you're hitting on kind of a topic I find really interesting is that, the lack of guidance on intangible transfer pricing is really only the tip of the iceberg in terms of the headaches that it caused taxpayers, right? You mentioned the limits on deductibility for different types of royalties, the need to break out royalty payments into constituent parts. I think one of the other issues that you've already kind of alluded to already, but I'd like to dive deeper into is this domestic Brazilian kind of patchwork of treatment of royalties, right? So when a taxpayer was brave enough to try to get royalty payments out of Brazil, at the federal, at the state, at the local level, those royalties were seen in different ways and treated in different ways. I'm wondering, Davi, can we expect relief for taxpayers or some more clarity or more streamlined approach to royalty payments with the adoption of the OECD standards, or do we expect these differences to persist?
I think that different interpretations from the state, city, municipality, and the federal government is expected once more because for softwares, for example, softwares doesn't need the register on the INPI, but every part of the state was fighting for its part of the revenue. So the municipality thinks that like a software license is a service. So it charges the Brazilian ISS, the municipal ISS. The state thinks that is a product and subject to the VAT. And the Receita Federal thinks that is a royalty subjected to all this analysis that was based on this legislation of the 64th. So that was something that I don't think that was addressed already in our transfer pricing rule in this new provisional measure. We do now have the figure of the arm's length approach to understand and to document the royalty transactions, but I still think that we will have these discussions for a while when we do have this kind of different interpretations for the organs in Brazil, for the municipality to the states and to Receita Federal. I do think that we still have a path to follow to define which are the best way and the best mode to avoid those controversies.
I think it's an important point to mention. It's a reason to curb the initial enthusiasm. It's very similar here in the United States, right? Mm-hmm. Federal law can, get us a long way towards, a common strategy or a common goal. But there is a significant in Brazil and the United States, a significant federal component of, the states and local authorities setting their own direction, their own policies. So we can expect that to continue in some degree, hopefully a little bit lighter than it has been in the past. Davi, I want to move onto a few other lenses of intangible transfer pricing in Brazil that I have heard from various industry practitioners are, areas of concern moving forward. So we've talked on previous episodes about this propensity, especially for foreign headquartered multinationals from the Brazilian perspective. So, let's say a U.S. headquartered multinational with operations in Brazil, about this propensity to treat, Brazilian legal entities as a transfer pricing island, quote unquote, right? To leave them out of intangible transfer pricing strategies and structures, right? To leave Brazil kind of on its own. A lot of taxpayers are looking forward to this new alignment because they can start to bring in the Brazilian legal entities into their global transfer pricing structures. Do you have some notes of caution to taxpayers who are working to integrate Brazil into their global transfer pricing policy, given this legacy of, what really could be seen as local IP, either commercial or technology, depending on what types of operations are at those Brazilian legal entities? Seen by the Brazilian tax authorities as, a buildup of historical legacy IP.
Yeah, I do understand that the Brazilian taxpayers have a lot to work on this following month. Because since Brazil took a part of those discussions of intangible transactions, of what are the intangibles that belongs to Brazil, or what are the intangibles that Brazil is consuming from abroad that is not being paid. And these discussions was not even put on the table in Brazil because of the previous legislation did not consider that. Now the Brazilian taxpayers will need to be educated on that. They will need to start learning and to understand on their house what they are doing nowadays that could be seen as a transfer pricing transaction, as a covered transaction based on this intangible rule now. Because since they are never seen these transactions before, since they are never discovered which would be the best way to remunerate it, if they need to be remunerated, or if it was just so difficult to charge those intangibles to Brazil. Brazil has never tried to look on that and see if there is any activity that is performed here in Brazil that should be charged abroad, or if Brazil is paying or should be paying the right amount to those transactions. So I think that is really necessary to take a deep look on their transactions, this understanding of which are the transactions that will be covered by the new transfer pricing rules, to understand what will be the impacts to the early adoption in 2023, and to be aware of the necessity to comply in 2024 forwards when the rule will be mandatory.
Yeah, Davi, I think that's a great point. And I think, we always talk about the alignment as something that adds certainty for taxpayers. And I think this is actually a case where, to some extent, it could push in the opposite direction for the exact reasons you mentioned, that this really just hasn't been on the radar of the Brazilian tax authorities before. And, using the example, a real life example from one of our clients, US headquartered, technical manufacturing company that's typically charged technology license or royalties to its affiliates around the world, except for Brazil. Narrative has always been, well, we don't charge Brazil because they have a unique local market, they have unique local operations. Royalty is really not as appropriate for Brazil as it is for everyone else. This client is super excited because they want to start charging that royalty into Brazil. I think that's great from a tax perspective, or a narrow lens of the tax and transfer pricing perspective, right? But it can really be a dangerous territory when you consider the broader context of, hey, look, for 15, 20 years, you've never been charging this royalty, and you've crafted a narrative that specifically gets around that royalty, whether that's for facts and circumstances, or whether that's due, maybe in part or a large part due to the non-deductibility. That's an area where just switching over from a transfer pricing implementation standpoint is not going to be enough. Finding any business case, that exists for making that change is really going to be important. Davi, switching tax, another question that I've really been hearing a lot from US and European headquartered companies is, do we expect that there's going to be any sort of carve-outs or different treatments of intangibles in Brazil? Like, we see this a lot in other Latin American countries, right? General adoption and application of the OECD standards, but certain carve-outs as relates to deductibility, the treatment of royalties, the ability to charge for different types of royalties, things that have existed for a long time in Brazil. Do we expect carve-outs from the Brazilian tax authority on things like, for example, IP cost sharing arrangements, which is a big planning idea for a lot of clients right now as they move to integrate?
Actually, cost sharing is considered. I don't know if a unique structure for the IT itself will be normatized by Receita Federal. And from what we do know now as a fact, we do have three different types of intangible transactions that was considered into the provisional measure. That was the intangible itself, and the definition that they put is the asset that, not being a tangible or financial asset, is likely to be held or controlled for use in commercial activities, and whose or use or transfer would be remunerated if the transaction occurs between unrelated parties. Regardless, whatever is subject to registration, legal protection, or to be characterized and recognized as an asset or intangible asset for account purpose, is the classic definition of intangible. The second would be the intangible asset difficult to value. There are the intangible assets for which it's not possible to identify reliable comparables at the time of their transfer between the related parties. and the projections of future income or cash flows or the assumption used for their assessment are highly uncertain. So there are two intangibles itself, intangibles and intangibles assets too difficult to value that I think that covers most of the other kind of type of transactions, of type of arrangements. And the third one are relevant functions performed in relation to the intangible activities related to the development, improvement, maintenance, protection, or exploitation of the intangible. That are the three cases that was defined in the provisional measure. And we think that will be a lot of normative instructions issued by the Receita Federal to address and to give more flavor to this intangible part, because we only have 4 articles in the full document. And we know that this is tricky, the part that you have more difficult to understand which are the limits different from the model that we are using with these fixed margins, with these mathematical formulas. This is complete economics. This is complete valuation. So I think that the Receita Federal will have a hard work to regulate all this stuff.
Exactly right. Thanks for that, Davi. I want to wrap up today by asking you, Davi, is there anything on your mind as kind of a new entrant into expertise in intangible transactions, right? Is there anything on your mind as a Brazilian transfer pricing expert that you're curious about or that you are nervous about, questions that you have for me in terms of how the OECD guidelines, US regulations treat intangibles?
No, questions is all that the Brazilian professionals, the Brazilian taxpayers have. I'd like to hear from you. What do you think that will be the biggest challenges by this adoption by the Brazilian multinationals? So nowadays, we know that most of the US companies has a hard time to work with Brazil on this session. But what are the main challenges and opportunities that you see that comes from this new legislation?
Absolutely, Davi. Yeah, I think the challenges we've discussed a little bit in terms of what I see as the biggest challenge. Ironically, I don't think it's going to be the implementation. The implementation is going to be complicated, but I think, the planning and structuring, even the operational transfer pricing can be managed. What I think is really going to be a challenge for companies is the qualitative aspect, the assessment of DMPI functions, doing functional interviews for entities that have really never thought about transfer pricing in that way, right? And crafting a consistent narrative that fits into the global transfer pricing narrative in your documentation, in your master file, right? There's going to be this tendency, like we talked about, to just change policies and not really think about the qualitative aspects, right? And I think we really run the risk, of kind of a sequel to the 3M case, right? 3M just got a very unfavorable ruling that basically the IRS is saying, look, you cannot design your transfer pricing around Brazilian transfer pricing rules, right? You can't design your global policy to accommodate global transfer pricing rules. The same thing is going to be applied on a look back basis, right? So the IRS is not going to be very sympathetic to companies that change their transfer pricing policies, start charging royalties, for example, out of the US into Brazil, and we're not, charging those royalties in the past where no business circumstances had changed. Figuring out, the confluence of the policy and the narrative is going to be extremely challenging, and it should be started already. Even if you're not going to implement until 2024, it should be started now. I think that's the biggest challenge. There's tons of other challenges that I would love to speak with anyone listening or any of the industry folks tuning into this podcast. We don't have time today, unfortunately. Opportunities, on the other hand, are also, at least offsetting, right? There's going to be, from a cash tax management perspective, unprecedented opportunity to realign your cash management goals across multinational operations, right? There's going to be better certainty in terms of deductibility. There's going to be utilization of the foreign tax credit, presumably starting in 2024 in the US, where that had been taken away for Brazil in the past. And really just the administrative burden, right, of not having to maintain basically parallel universes of transfer pricing for Brazil and the rest of the world. Obviously a huge opportunity. Davi, answer your question fair enough, or anything else?
No, I think that's it. We don't have much time today. We still need some regulation, some position from Receita Federal to avoid unnecessary surprises in the future.
Absolutely. And Davi, I wouldn't be doing my job if I didn't plug a service that BaseFirma is offering, right? Part of our ear to the ground in terms of what folks in industry are focused on as part of our meetings and roadshows that we've already held as part of this overall effort and push to get ahead of the alignment and changes that we're expecting in Brazil. We're offering a service that's very, simply put, a feasibility assessment, not only looking at the applicability or the benefit to individual taxpayers, fact patterns of whether they might want to adopt these optional policy changes in fiscal 23, defer to 24, right? So kind of dry runs, mock-ups. Davi, I wanted to give you the chance to add anything in terms of these assessments that we're doing and offering to the market, and any other comments that you have in terms of what folks might be looking for.
Yeah, the perfect timing to start this analysis. If you are looking to apply in 2023, is mandatory. If you are not looking for 2023, just 2024 is really recommendable because you start educating your company, educating and understand your transactions and make the necessary adjustments during the calendar year 2023 as you can start 2024 already in compliance with the new guidelines. So that's something that we are offering to our clients. And together with this analysis, also in-house training based on the results that we get from those assessments. So we can educate, we can train the team to understand what are their parts on this new transfer pricing environment and make their aware of any other transactions that may raise on 2023 that they needed to be alert for 2024 forwards.
Excellent. Well, thank you so much, everyone, for tuning in today. You can find Davi's contact information, my contact information, and the podcast details. We're really looking forward to hearing from all of you, and we're looking forward to tuning back in next week with our next installment. Thanks, Davi.
Thank you, sir. Bye-bye. Um abraço.
Abraço.